अपील कीजिए, मदर को क्या criminal appeal still. Give criminal appeals, no problem. Provisional bail. I want provisional bail. Provisional bail for? Mother has been died. Appeal mother has been died. Kal going on 17th. कल लगा.
Before mentioning, Your Lordship, it's a matter of 30A of Excise Act, Your Lordship. May kindly list it tomorrow, Your Lordship.
It will be listed as per its turn.
Your Lordship, it has not been listed, Your Lordship.
Others have done some wrong.
Your Lordship.
That your matter will come first and their matter.
Friday list.
No, Your Lordship. Friday it will come, but as per its seniority.
I am mentioning the serial number 3, Lordship. I put up after summer vacation, Lordship.
No problem.
My Lord, may I permit to serial number 24, my Lord?
You want all adjournment, he will grant.
No, adjournment, no, my Lord. This is at serial number 24, my Lord.
24.
Marriage of the sister of the petitioner is held on, my Lord. Is going on 14/5, my Lord.
We are taking mention when it is called out.
My Lord, serial number 10, my Lord.
Maybe my Lord heard as a last case, my Lord, today, my Lord.
17th
14 को शादी है.
17th को listed है. Serial number 10, my Lord. इसमें
10
percent
को adjournment दीजिए. 10 को you want adjournment in 10?
10 serial number 10.
Yes, give adjournment.
17th को.
Yes.
My Lord, criminal misdemeanor number 962 2022, my Lord, Excise Act.
Yes.
7 months से जेल में है, कस्टडी.
उसके जो नीचे लोग हैं या ऊपर लोग हैं, उन्होंने क्या गुनाह किया? सीरियसली आएगा वो, सीरियसली आएगा.
My Lord, in extraordinary circumstance, I am mentioning one case for hearing out of turn, my Lord. Because the petitioner is seriously ill. The jail doctor has sent him to the SKMCH for treatment, my Lord. The jail authority has also sent one letter to the son of the petitioner to go and serve the jail.
बताइए क्या है, बताओ, मुझे बताओ. Where is that letter?
Yes, that I have entered, my Lord.
ये इसको दे दीजिए कल दे दीजिए.
Permission, my Lord, for mentioning in criminal appeal number 1198 of 2021, my Lord.
Criminal appeal.
Out of my Lord.
Give it to him, criminal appeal.
My Lord,
May I?
It will be taken up. Wait.
May I
Yes.
permit to mention? Lord?
Yes.
Appellant is minor.
Appellant is minor. So
Yes, Lordship. Or his custody is 26/11/2020, Lordship.
so
My prayer is, or it is.
how you are saying that he is minor?
JJ Act मैटर है लॉर्डशिप.
हाँ?
JJ Act के अगेंस्ट अपील में आया हुआ है. अपील है लॉर्डशिप JJ Act में.
JJ Act.
यस लॉर्डशिप.
हाँ.
जुबलाइन जस्टिस एक्ट में.
ओके. क्यों अपील का सर्कुलेशन देंगे, जब आएंगे तब मिलेगा.
With the greatest apology, Your Lordship, due to extraordinary compelling
Yes.
situation, Lordship, I may be permitted to mention case, Lordship. Petitioners are the permanent residents of UP. They are tribal, Lordship, and his wife is pregnant and she is hospitalized, Lordship. So only because of that, because he is the only person who will take care of her, Lordship,
Yes.
and he is in jail since more than 8 months, Your Lordship.
Others are also. Yes.
Heading for orders withdrawal. Serial number 1, Mr. Rajkumar Rajesh Ashok Kumar.
You want to withdraw the
Heading for orders. Serial number 2, Mr. Divakar Upadhyay and Mr. Pankaj Kumar Sinha.
You are not audible.
fine.
I am unable to hear you.
In this case, Lordship, 7 years punishment, Lordship. I have completed 7 years, Lordship. More than 7 years in custody, Lordship.
So you will be let off by the jail authority. If it is 7 years
Lord.
have been completed, you will be let off by the jail authorities.
Jail or jail was because jail authority are not taking
No,
any
how they can detain
taking
you?
any action, Lordship, because
Huh?
16/4/2000.
But how they can put you behind the bars for more than the period of sentence?
16/4/2015 से हम जेल में हैं.
So you convince the jail authorities that your sentence is over. If you want to argue it finally, I will hear you.
Also, Lordship,
Okay, we will hear you. Sure, start.
appeal is still
Start.
pending, Lordship.
Start. We will hear you. We are hearing you. Is there any law that if appeal is pending, sentence is undergone, still the appellant is to be detained? Which is that law or rule? If sentence is complete, they are bound to release you. But if you are saying that yes, you want to argue the appeal, start. We are ready.
Lordship.
Yes.
Format.
Where is the charge?
Charge, Lordship.
This is appeal. What is name of your client?
Muhammad Islam.
Mohammed.
Umar, Lordship, at the time of
His accused number.
one milord, only one accused. Accused number one, Lordship.
Muhammad Islam.
Muhammad Islam.
Yes.
The judgment
What is the charge against him?
Lordship charge under section 157, 148,
157. What is that 157?
Lordship
157 of which act?
147,
147. Okay. 147,
148, 323, 325,
320,
506 for 452 IPC Lordship, and 376 of the IPC, and 3, 1, 11 and 12 of the SC, ST Prevention of Atrocity Act.
the same day and same
In this case, Lordship,
where is the judgment?
7
Judgment.
Lordship at page number 3, Mantabya Lordship,
Page number?
finding Lordship, page number 3 of the judgment Lordship.
Read conviction part.
Lordship.
Supplementary bail application, my lord. Date of occurrence, my lord, 15/9/2020, my lord.
Yes.
And date of reporting, my lord, 23/11/2020, my lord, after 2 months 8 days, my lord. और डिस्प्यूट हुजूर है कि इनके पति राज मिस्त्री हैं हुजूर, और एडवांस मनी इन्फॉर्मेंट ली थी, और एडवांस मनी हुजूर ली थी, और इनके पति हमारे मकान में कंस्ट्रक्शन नहीं कर रहे थे. यही हुजूर डिस्प्यूट है. और ये रहती है हुजूर सासाराम में, और ये वहाँ की रहने वाली भी नहीं है, कुसहार विलेज की रहने वाली भी नहीं है. वहाँ इनके पति राज मिस्त्री का काम करते हैं.
देखिए
Third, Mr. Raghunandan Kumar Singh, learned advocate for the petitioner, and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. The petitioner is alleged to have attempted to molest the prosecutrix in the night of 15/9/2020. While pressing for anticipatory bail, the learned counsel for the petitioner urged that with respect to the occurrence of 15/9/2020, the case was filed on 23/11/2020, and that also without any explanation whatsoever. He has further submitted that it's a false case which has been set up by the husband, a false case, and the prosecutrix has been set up by her husband, who in his capacity as mason had accepted an accommodation loan from the petitioner but had not been working in the construction of the house of the petitioner.
You have a next step.
Considering the aforenoted facts and taking into account the report, the petitioner is directed to be released in the event of arrest to surrender 10,000. While saying so, the court has also taken note of the fact that the prosecutrix does not even stay in the village, rather does not even stay in Sahara, but in her village home, and the petitioner has got no concern with the village in which the prosecutrix resides.
72, Mr. Rajkumar, right witness.
More than 1 year. Same reason, yes.
According to FIR, there is
Offense
allegation
under
against
section?
11 accused persons. They assaulted to 4 persons, my lord. My case is earlier, my lord. First,
What is the nature of injury?
petition number 1, Umesh Mathur was arrested, my lord. On bail,
Injury of 4 persons.
4 person annexure 2 series opinion reserved, my lord, and annexure 3 series simple in nature. Father of the petitioner number 6 was killed by annexure 3, my lord. Annexure 4, my lord. My case is earlier 295, my lord. Thereafter this present case filed 296, my lord. 3 person injured and father of the petitioner number 1 killed by annexure 4, my lord.
Yes, you are for the informant.
Yes, my lord.
Tell us.
Lords, 4 to 5 persons, there was free fight between both sides, my lord, and 4 to 5 persons have been brutally assaulted. FIR नहीं है किसी का हाथ टूट गया, किसी का पैर टूट गया.
Sir, most of the injuries are simple except few about which opinion has been reserved.
Yes.
Persons from both sides have been injured. And somebody who was the petitioner here, he has been taken into custody, granted bail. So there is no great fun in asking them to surrender before the court. Why not anticipatory bail? Again,
My appearance,
heard Mr. Rajkumar, learned advocate for the petitioners, and Mr. Sanjeev Kumar for the informant. The state is represented by so-and-so. Mr. Rajkumar seeks permission to withdraw the application with respect to petitioner number 1, who has been arrested during the pendency of this petition and has been granted regular bail by the court below. The petition with respect to applicant number 1 is dismissed as having become infractious. Petitioners number 2 to 6 seek bail in anticipation of their arrest in connection with so-and-so. Though all the petitioners are said to have taken part in the assault, but 4 persons only have been injured. There is a counter version of the case also, in which petitioner number 6 and his relative have been injured. The whole dispute is with respect to a plot of land
And died also, my lord.
Just a minute. Father of
No, name of the petition number 1, Umesh Mathur, my lord. Umesh Mathur के नाम से जमीन
तो मेरी आवाज नहीं सुनाई देती है या पता नहीं समझते नहीं है.
Annexure 5 है वो जमीन petition number 1 के नाम से है.
तो आपने पिटीशन में 6 क्यों लिखा है?
petition number 6 के फादर की Para 11, my lord. Page 5.
Is registered in the name of father of petitioner number 6, but the informant and his other family members. Read paragraph 12.
For land of
Such simple facts also you make contradictory statements, and then you're not ready with your own petition.
No, my lord, but
Sorry. Let this matter be listed after the summer vacation. चलिए next.
सेल फोर मिस्टर विकास कुमार पंकज
इसको पास ओवर कर.
आप एक अपनी पैराग्राफ नहीं पढ़कर, when I'm dictating the order from your petition, you're causing obstruction.
देन वो जो गलत लिखो सुधीर मंडल के नाम से ही
तो फिर क्यों लिखा है petition में आपने?
वो जो petition number 6 का वो गलत
You should have said that before.
petition number 6 का
I'm sorry, we will not spend so much of time. We have given you priority hearing and you're not ready in your matter.
No, my lord, I am
Pass over,
sorry, my lord.
Tomorrow.
सेल थ्री मिस्टर अर्जुन प्रसाद सेल थ्री मिस्टर अर्जुन प्रसाद
Yes. What is the urgency?
This case may not be
1 year. Same year. Yes.
case of not Excise Act.
Yes.
The name of the petitioner has come on the confidential information of the police that 7 persons are indulged in the business. And when the police came, Lord, it is stated that 2600 liters of spirit is said to have been recovered from a vehicle.
What has been recovered?
Spirit.
200 liters. 2600 liters.
And 2 persons were seen fleeing away. I am not amongst them. One of the person who was fleeing away was granted bail by your lordship, this Manan Kumar Singh. I have got the order.
No, that's all right, but who are you?
I am the person who is named on the confidential information that
You are dealing in liquor.
I am dealing.
All right, begin. Heard Mr. Vikram Dev Singh, learned advocate for the petitioner and so for the state. The petitioner seek in anticipation of his arrest in connection with so and so. Stop. The police received. It appears that the prosecution report indicates that on secret information by the police that 7 persons, including the petitioner, are dealing in liquor. A raid was conducted and 2600 liters of spirit was recovered. First of 2 persons were found to be running away from the place of raid, one of whom has been granted bail by this court. Land counsel for the petitioner has submitted that his implication in this case is only on the basis of secret information to the police that he is also involved in purchase and storage of liquor, which the petitioner denies. In support of his contention, the only ground that has been argued is that the petitioner does not have criminal antecedents and that his accusation is based only on guesswork. Considering the aforementioned submissions, the prayer for grant of anticipatory bail is allowed. The petitioner is directed to be released and 1,000 insurance.
for Mr. Vikas Kumar Pankaj.
Please. Urgency? Why the matter has come today?
My lord, the mentioning had been made yesterday
for some urgency, no?
My lord, 82, 83 proceedings had been initiated. 82 proceedings have already been initiated.
No, but where is your slip? Mr. Mrigank Moli, where is your slip?
पहले प्रायोरिटी बेसिस चला
Only
था
on oral mentioning that.
पहले प्रायोरिटी बेसिस चला था फिर अर्जुन होगा इसके बाद
It was heard once.
My lord, it was heard in virtual mode last week.
He is stated to be a government employee working in health department who has served as a pharmacist during difficult work. All right, this was heard
That
on
was
24th of March.
My lord. And thereafter, yesterday it was mentioned, my lord, for the reason that 82
right,
proceedings
yes.
have been initiated, my lord.
What is the matter?
My lord,
Your Lordship, for the informant, I may be permitted to file the affidavit already on record through pre-filing, but for verifying.
we have already filed the rejoinder
Counsel
to
for the informant has filed a counter affidavit during the course of argument across the board. Let it be taken on record. Yes.
my lord, the allegations
Read
are
the FIR.
my lord. It begins at page 20, my lord. उपर्युक्त विषय के संबंध में कहना है कि मैं पिंकी कुमारी पुत्री श्री रामेश्वर प्रसाद अग्रहरी निवास स्थान राजा बाजार बेली रोड पटना की निवासी हूँ। मेरा पोस्टिंग 2015 में कोइलवर में एएनएम में के पद पर हुआ है। कोइलवर आने जाने के क्रम में मेरी मुलाकात 2015 में ही पंकज कुमार श्रीवास्तव पुत्र उपेंद्र कुमार श्रीवास्तव निवास स्थान फ्लैट नंबर 304 विनोद कुंज प्रियदर्शनी सोनसुर बेहिया में फार्मासिस्ट पर कार्यरत है। जिसके बाद पंकज कुमार श्रीवास्तव ने मुझे शादी के लिए प्रपोज किया एवं 2016 में ही इन्होंने मुझे अपने परिवार के सभी सदस्यों से मिलवाया। इसके बाद पंकज कुमार श्रीवास्तव मेरे पूरे परिवार से मिलवाते एवं भरोसा दिलवाते कि वो मुझसे जल्द ही शादी कर लेंगे। 2017 में इन्होंने मुझे फ़ोन करके बताया कि इनकी मां की तबीयत खराब हो गई है एवं पंकज कुमार श्रीवास्तव मुझे खुद लेने भी आए। जब मैं उनके निवास स्थान विनोद कुंज फ्लैट नंबर 304 में पहुंची तो वहां कोई भी नहीं था। मैंने पंकज कुमार श्रीवास्तव से अनुरोध किया तो मुझे मेरे घर पहुंचा दे, परंतु उन्होंने ज़बरदस्ती मुझसे शारीरिक संबंध बनाया एवं मुझे शादी के लिए आश्वासन दिया। इसके लिए उन्होंने मुझे विश्वास दिलाने के लिए लगातार अपने परिवार के सभी सदस्यों से मिलवाते रहे एवं अपने परिवार में ये बोलकर कि मैं पिंकी जी से शादी करूंगा, मुझे अपने परिवार के साथ घुमाते ले जाते थे। अपने सन 2019 में जब कोविड आया तो मेरी ड्यूटी ब्लू हेवन रेस्टोरेंट में पड़ी थी, जिसमें ये मेरे साथ ये बोलकर जाते थे कि आप मेरे होने वाली पत्नी हैं। 2019 में मैंने पीएचसी रोड थाना मोड़ में रूम किराए पर लिया, जिसमें इन्होंने मकान मालिक को हमारी सगाई के बारे में बताया एवं मेरे मना करने पर ज़बरदस्ती मेरे साथ रहते थे। ये बोले कि मैंने अपने परिवार को बता दिया है। एक बार शादी का झांसा देकर शारीरिक संबंध बनाते थे। 2021 में मैंने फिर रूम लिया। मेरी ड्यूटी को देखते हुए रेलवे स्टेशन चौक गुप्ता की भंडार के पास मकान मालिक का नाम रोशन, वहाँ भी मेरे साथ ज़बरदस्ती रहे और मेरे साथ शारीरिक संबंध बनाए। जब मेरा परिवार रिश्ते की बात आगे बढ़ाया तो ये बोलकर कि नीच जाति के हैं और मैं ऊंची जाति के हैं और आपको सफ़ेद दाग है, इसलिए मैं अपनी शादी नहीं करूंगा और शादी के लिए मना कर दिया। मतलब माननीय महोदय से उचित कार्रवाई की जाए। Now, my lord, even prior to this, my lord, the first information is at annexure 6 at page 32. Now, my lord, just give me 1 minute. Sorry, ma'am.
And someone like you are clueless, you don't know anything about the brief. When you want the matter, nothing. You don't know anything.
Don't make a mockery of the court proceeding.
By way of last indulgence, the matter is adjourned to Tuesday.
My lordship, may pass it over. Mr. Vinay Mistry is on in other court. My lordship, on it may be passed over for the day.
So, here also the matter was passed over on 5/5/2022. You are again seeking pass over.
My lordship, I will inform him.
By way of last indulgence, the matter is adjourned. As requested on behalf of the petitioner, the matter is adjourned to Tuesday.
This is an application for this application is relates to initiation of certificate proceeding against the rice miller, with whom there is no agreement. There is agreement, but there is no such stipulation that there should be a initiation of the certificate proceeding. That is annexure 1. That is the agreement, your lordship. The similar matter was came before this lordship consideration before the honorable single bench, and the Lordship was pleased to hold that because there was no stipulation in the agreement, therefore the certificate procedure will be not be applicable in the present case, Your Lordship.
मुझे नहीं पता तेरे पापा को कुछ करते हैं, मुझे तो पता लगा मैं कुछ दिखा रहा
Thereafter, the matter is pending before the consideration before the Honorable Apex Court. However, the protection was given is that the no coercive steps shall be taken against the petitioner before the Honorable Apex Court. So, Lordship, in light of that order, Your Lordship, I am also seeking the protection because the consideration is pending before the Honorable Apex Court that whether the certificate proceeding would be applicable in the case of.
Sir, counsel, that is an order passed by the Supreme Court in that case, the facts and circumstances of that case, which is an interim order. A final order has been passed by this court, which has not been stayed by this court.
The stay was granted, Your Lordship. The no coercive stay was.
Coercive is for that petitioner.
So, Lordship.
Before us, yes. there is a decision of.
So, Lordship, I am also just seeking a Lordship's consideration, Lordship, because there is.
File your objection.
The agreement is Annexure 1, Your Lordship. There is no such stipulation in the agreement, Your Lordship. That is Annexure 1, may kindly turn to page 16, Your Lordship. There is no such stipulation that the.
Can any kind of a demand be recovered under the PDR proceedings without agreement?
No, Your Lordship.
No.
So far the Act is concerned, Your Lordship, we understood from the Act, Your Lordship, that there must be a written agreement, written instrument, Your Lordship.
Please have a relook at the provision. The agreement is required in respect of demands made by certain authorities and bodies and banks.
Lordship.
Otherwise, public demand is a demand due to the state. The provision is so exhaustive. All the demands are not to be supported by an agreement inter parties.
That was taken care of, Your Lordship, by both the benches of this Honorable Court, Your Lordship, and therefore the matter travel up to the Honorable Apex Court. This issue is still pending for consideration that whether the agreement in where there is no such a stipulation, whether the
consideration, the matter is finally decided by this court.
Yes, Your Lordship, but thereafter the
we don't know the facts of that case.
I have annexed
final decision by Supreme Court.
I have enclosed the order, Your Lord, of the Honorable Apex
That will
Court.
not serve any purpose.
That is at page.
That is in connection with that case.
Several matters went before the Honorable Apex Court, Your Lordship. Annexure 4, page 27, Your Lordship.
Maybe.
Notices were issued, Your Lordship, and
Why did you not file any objection?
Lordship, this case, Lordship, that was decided in the year 2013 itself, Your Lordship. Thereafter, the petition sought time to file a supplementary objection. That was not under the law, Your Lordship, but that was the fact of the case, Your Lordship. Thereafter, the PSFC filed their counter affidavit, and the matter is still pending. And
no, sorry, the proceeding was initiated in 2013-14.
Yes, Your Lordship.
And you came here in 2021.
Because when the annexure 5 was issued against the petitioner, Your Lordship, the petition moved before this Honorable Court in the light of the development taken place in the matter related to the rice miller, Your Lordship.
Section 10 already decided what to. So you should have gone there and you could have told them. This is simple a notice.
Yes, Lordship.
Kiya jayega, and you have come to the High Court.
So protection may be given, Lordship. I am just seeking that I am.
Section 10 order already
What
passed.
protection? There is a notice, you have to give your response under section 9. So what is the occasion for seeking any protection right?
My lord. Section 10 order already passed 2013, my lord. That order never challenged, my lord. Last 9 years, my lord, never turned up before the certificate official, my lord. Then notice already issued, my lord.
Section 10 order has been passed.
Yes,
Section
Lord, that was
8-7, my lord,
passed.
supplementary affidavit, 2013, my lord.
But your lordship, thereafter the counsel for the petitioner was appearing in the matter. They filed a supplementary objection, your lordship. That was taken note of, your lordship. Thereafter the BCFC also filed a counter affidavit, counter objection to the supplementary objection, and that is pending. Certificate case is still pending. So I just pray, your lordship, I may move before the for appeal, your lordship, and meanwhile, your lordship,
You have misused the process of law. Certificate.
lordship, liberty may be given that I may go for the
whatever you want.
filing of objection, your lordship.
Where is question of objection? Question of objection, supplementary objection, objection after section 9. Then no coercive. You are not section 60. Even responding to the notice which is issued to you. Section 60, my lord, appeal, my lord. 60 appeal and 62, my lord, revision. That order, my lord. Last 9 years never filed, my lord.
No, I was appearing in the certificate case, your lordship. I filed in supplementary objection, and thereafter because there was a vacancy in the order, your lordship, because there were 3 or 4 years nothing was taken place, your lordship. Thereafter again the notices were issued to me, your lordship. That is annexure 5, page 29, your lordship.
Sorry, you have misused the process.
Therefore, your lordship, I am seeking your lordship's indulgence, your lordship.
Whatever you want to do. Otherwise, our observations are going to be very strong.
Lordship, I am just praying, your lordship, that liberty may be given to petitioner to move before the filing appeal, your lordship, before the appropriate authority.
Lord counsel for the petitioner after some argument seeks permission to withdraw this application with the liberty to take recourse to appropriate provision of law under the Bihar and Odisha Public Demands Recovery Act 1914 so as to assail the impugned action of the certificate officer. First up, next. Without commenting on the question of condemnation of delay, the petitioner is granted, this application is disposed of as withdrawn with the liberty to the petitioner to prefer appeal for appropriate authority.
The delay, lordship.
Delay of 10 years.
Lordship, I have a entire order sheet of the certificate proceeding, lordship. That is still continuing. So, lordship, the petition was under impression that the matter is still pending before the certificate officer. So, because of that observation, lordship, I may be not be able to prefer the appeal because there is a huge amount, your lordship. So, I have to.
You are under the impression that you are not liable to pay.
No, no.
They are under the impression that you are liable to pay.
The money must be recovered, but that
not decided.
money must be recovered, but that
on the basis of,
Lordship, the money must be recovered, but under the due process of law, Lordship.
Sorry.
Sir, the Lordship, the delay may be taken note of, Lordship.
Delay you may pursue.
That objection may be not given, Your Lordship. Simply, I may permit to file an objection.
Fine.
That delay.
Limitation of duration.
Highly object.
Serial number 23, CWSC 12436 of 2021. Messrs. New Monto Surgical Versatile State of Bihar for the petitioner Sri Ram Shankar Das for the estate Sri Ketu Prasad.
Lordship, may I please your Lordship in this matter earlier by order dated 5th of May, State was directed to seek information whether the appeal is pending. If it is pending, then by what time it may be disposed of. We have sought information regarding that, and by later dated 5/5/22, we were instructed that appeal is pending, and within 4 months that is going to be disposed of. This is stand of the state.
Lordship, in this case, clerk of Mr. Ram Shankar Das has requested me to make a prayer for adjournment, Your Lordship. There has been some bereavement.
No, they are going to dispose of the appeal.
I am not concerned with this case. His clerk has requested me to make a prayer for adjournment.
Requested on behalf of an adjournment is being sought on behalf of the petitioner. That counsel for the estate has informed this court on the basis of the instructions which he has received that the appeal which is pending before the appellate authority filed by the petitioner on 24/2/2021 shall be disposed of within 4 months.
4 weeks.
4 weeks from today.
We have offered higher price than whatever, because it was in pandemic, Your Lordships, there cannot be maximum participation, and sale was conferred in favor of sole bidder.
So what are you expecting from this court?
Your Lordships, my submission, Your Lordships,
Not your submission, what is the order that you want from the court?
Your Lordships, my objection to the extent which was prior to the sales must be allowed to the extent that he offered higher price than the bidder.
So therefore you are challenging the order of the recovery officer. He has rejected your objection on the point of valuation.
That ought to have, Your Lordships, that ought to have been done prior to auction sale. But recovery officer rejected my objection after the auction.
When did you give your objection?
1 day before the auction sale.
So
on that
how could it be decided before he has recorded that at the last moment you have made the objection, you had all the opportunity, you have not
At
done
that
so.
time, since pandemic was there and limitation was continuing, limitation was condoned by that was the limitation was extended up to the February 2022.
The order is appealable.
Yes,
Your
appealable.
Lordship. Then go in appeal. Where is the question for the writ court to enter into this valuation issue?
Under section 30 is applicable.
Yes.
Liberty.
Yes. Liberty is there. Not say anything.
Your Honor, but this is my submission is
The
this is
learned
arbitrary.
counsel for the petitioner, after some argument on the alleged undervaluation of the auction properties, submits that he would be availing his remedy of appeal under the statute. So in view of such submission, no orders are required to be passed in the instant proceedings, and the same is disposed of.
Your Honor, limited time consumed may be condoned under section 40.
Serial number 25. CWJC 12501 of 2021 with CWJC 12586 of 2021. For both the cases, learned advocate for the petitioner, Shri Sanjeev K. For both cases, learned advocate for the state, Shri Abbas and Rishi Singh.
Lordship. Annexure P8 page 40 is under challenge, Lordship, by which petitioner has been blacklisted for indefinite period, Lordship. Debarred for indefinite period, Lordship. May I read the letter, Lordship, at page 40, Lordship. E-tender 10/2019-20 के ग्रुप संख्या 1 योजना संख्या 1 के अंतर्गत कंस्ट्रक्शन ऑफ कॉन्फ्रेंस हॉल इन म्यूनसिपल कॉर्पोरेशन ऑफिस मुंगेर बिहार कार्य का करारनामा सो एंड सो के साथ किया गया तथा कार्य आदेश दिनांक सो एंड सो द्वारा निर्गत किया गया था। कार्य पूर्ण करने की तिथि 13/8/2020 थी, जो समाप्त हो चुकी है। निर्धारित अवधि बीत जाने के पश्चात भी संवेदक द्वारा कार्य पूर्ण नहीं किया गया है। संवेदक को इस कार्यालय के पत्रांक सो एंड सो दिनांक 15/6/2020 एवं पत्रांक सो एंड सो दिनांक 27/11/2020 एवं पत्रांक सो एंड सो 18/12/2020 एवं पत्रांक सो एंड सो के द्वारा उक्त कार्य के कार्यान्वयन हेतु स्मारित किया गया है। इस कार्यालय के पत्रांक सो एंड सो 19/5/2021 द्वारा स्पष्टीकरण पूछा की गई है। संवेदक के पत्रांक 24/5/2021 द्वारा स्पष्टीकरण प्रतिवेदन समर्पित किया गया है, जो असंतोषजनक है। नेक्स्ट पारा इज लॉर्डशिप। संवेदक द्वारा उक्त कार्य बहुत ही धीमी गति से कराई जा रही है एवं पिछले 1 माह से अधिक समय से कार्य पूर्ण रूपेण बंद रखा गया है, जो खेद का विषय है। कई पत्राचार होने के बावजूद भी संवेदक की रुचि उक्त कार्य के प्रति नहीं दिख रही है। कार्य समय पर पूर्ण नहीं होने के कारण निगम को राजस्व की क्षति हो रही है। अतः संवेदक सो एंड सो माधवपुर मुंगेर को अगले किसी भी निविदा में शामिल होने से डिबार किया जाता है। यह आदेश तत्काल प्रभाव से लागू समझा जाएगा। Thereafter, my lord, Annexure 9 has been issued, Lordship, which is at page 41, Lordship. By which a show cause was issued for blacklisting the petitioner, Lordship. Relevant is after 4 and 5 line, Lordship. आपके द्वारा कॉन्फ्रेंस हॉल के दीवार में बिजली वायरिंग हेतु कटिंग कर पिछले 1 सप्ताह से छोड़ दिया गया है, परंतु मलबा ज्यों का त्यों छोड़ दिया गया है, जिसके कारण दो हस्ताक्षरी के कार्यालय कक्ष में हवा चलने के कारण धूल भर जाती है एवं सरकारी कार्य को संपादित करने में बाधा उत्पन्न होती है। उक्त कार्य के संपादन में आपकी अभिरुचि नहीं दिख रही है। कार्य समय से पूर्ण नहीं होने के कारण राजस्व की क्षति हो रही है। आपके द्वारा उक्त कार्य का कार्यान्वयन बहुत ही धीमी गति से कराया जा रहा है, जो अत्यंत खेद का विषय है। Lordship, so cause was asked, Lordship, which is at page 37, Lordship, P6, Lordship.
Where is the legality?
Lordship.
Where is the legality in the order?
Lordship, I have filed the so called, Lordship, stating all the facts, Lordship, which is at Annexure 7, Lordship. Which is shot from page 38. Typed copy is also annexed with, Lordship. May I read that, Lordship? उपयुक्त विषय प्रासंगिक पत्र के आलोक में कहना है कि दिनांक Lordship,
you are challenging the notice, or you have been blacklisted?
I am challenging the annexure P8 by which I have been debarred by the authorities, Lordship. At page 40, Lordship.
You have been debarred because you are not completing the work.
Lordship.
Have you completed?
Lordship, work has been already completed, Lordship. Lordship,
already might have been completed. Respond to the notice first.
I am challenging the order of debar, Lordship, not for the blacklisting. Annexure P8, Lordship. I have stated each and every fact before the authority.
We are not satisfied.
Lordship,
we are not satisfied. We are not inclined to interfere. And then you have been put on notice by annexure P8. Have you responded?
Lordship, I have responded to P7, Lordship.
P8.
P6, Lordship. By P6.
Sorry, P9.
P8, 69 and 74. My lords, I shall be brief because I want to finish my argument in 2 days' time, my lords. The argument with regard to criminal writ. Therefore, my lords, I chose in particular only to suggest the relevant paragraphs. If your lordships will turn to para 68 of the judgment.
Yes.
My lords, here is, my lords, what is a realistic view taken by the apex court with regard to disease that corruption is all pervasive. And this is what they say. Today, corruption in our country not only poses a grave danger to the concept of constitutional government, it also threatens the very foundation of Indian democracy and the rule of law. The magnitude of corruption in our public life is incompatible with the concept of a socialist, secular, democratic republic. It cannot be disputed. Corruption begins all right and a short sentence, but possibly very descriptive and very illustrative sentence. Corruption devalues human rights, chokes development, and undermines justice, liberty, equality, fraternity, which are the core values in our preamble vision. Therefore, now, my lords, the Supreme Court's, my lords, statement with regard to how corruption laws are to be interpreted. Therefore, the duty of the court is that any anti-corruption law has to be interpreted and worked out in such a fashion as to strengthen the fight against corruption. That is to say, because these are the 2 lines which I will be emphasizing upon. That is to say, in a situation where 2 constructions are possible, eminently reasonable, the court has to accept the one that seeks to eradicate corruption to the one which seeks to perpetuate it. Not seen in context of para 1, the issue which was there before the Supreme Court, whether PC Act not expressly providing that a private complaint could be maintainable, it being eminently reasonable interpretation that a private complaint at the hand of a person seeking to prosecute is a reasonable view, and it tends to deal with cases and incident of corruption, because the verdict in, according to me, Lord, subject to correction from your Lordship's side, that is how, and it is not an authority to say that an interdict of a statute, if it falls within the express words of the interdict, is to be ignored. obliterated as if, my lords, that sub silentio was being held ultra violence. This is my input.
you're right. Proceed further, Mr. Singh.
My lords, that 69, my lords. Time and again, this court has expressed its dismay and shocked at the ever-growing tentacles of corruption in our society. But even then, situations have not improved much. And then kindly come to Paras 74, my lords. Keeping those principles in mind, as we must, if we look at section 19 of the PC Act, which bars a court from taking cognizance of cases of corruption against the public servant under section 7, 10, 11, 13 and 15 of the Act, unless the central or state government, as the case may be, has accorded sanction, virtually imposes fetters on private citizens and also on prosecutors from approaching court against corrupt public servant. These protections are not available to other citizens. Public servants are treated as a special class of persons enjoying the said protection, so they can perform their duties without fear and favor and without threat of malicious work. However, the said protection against malicious prosecution, which was extended in public interest alone, cannot become a shield to protect corrupt office. These provisions, being exception to the equality provision of Article 14, are analogous to the provision of protective discrimination, and these protection must be construed very narrow. Second aspect is that this protection has to be construed narrow. Because I am not only citing paragraphs which may favor me, my lords. I believe in, my lords, realizing what obstacles lies in front and see if within the four corners of the law I am able to meet them, overcome them, or they are overcome. These procedural provisions relating to sanction must be construed and in such a manner as to advance the cause of honesty and justice and good governance as opposed to escalation of corruption. Plus, this judgment was the second aspect that I would like to highlight while placing this judgment, is of the year 2012. Must have been delivered either early 2012 or, my lords, in the year 2011. Section 17A, my lords, was on only in August 2018. I mean, that is all. It was with regard to whether private complaint would lie. They said it is eminently reasonable for...
This has got nothing to do. Now, in all the cases governing 17A, I mean, just to remind you, in all cases governing section 17A, the interpretation which has been given, the references of this case, the orientation is towards interpretation of 17A in the manner in which it should be. So therefore, you need not labor on this point that this was in 2012, 17A came later, it came in 2018. So this is only for this, that it has to be interpreted in such a way that it prevents escalation of corruption and does the otherwise.
My lords, I am so thankful to my lords. What your lords have said in certain unsaid words are that if the choice is not an alternative choice but is hit by the statutory indictment, then that logic doesn't apply. Lords, I am only now going...
And you have said that. You have said that you have repeated that line twice, that this protective discrimination has to be construed narrowly. And it has to be with the object. So therefore...
I hope, my lords, as an officer of the court, I will not be suppressing any paragraph either intentionally or otherwise, my lords. But then, one has to go by law which uniformly applies.
Yes, next case, sir.
My lords, next case is a case, my lords, which doesn't find mention in the counter affidavit of my learned friend appearing for vigilance. But it is a case which has dealt with 3 Kerala judgments and Devendra Kumar, a case from Delhi. Because I am citing 2022 SCC online, page 397. The party name is, my lords, Rajesh Kumar versus State of... I have given a copy, my lords, of SCC online. My lords, is 2020... My lords, with regard to facts, my lords, only for a brief purpose before I take your lordships to the relevant paragraphs.
Are you referring to that judgment by Narayan Pishardi?
My lords, let me see the honorable...
T.O. Suraj.
Vijay Vishnoi, Justice Vijay Vishnoi, Rajesh Kumar. Rajasthan High Court, my lords, 2022 SCC online, Rajasthan 397.
Yes.
My lords, 2 cases only, one and one other, before I take your lordship through facts pure and simple. My lords, these are the propositions as Devendra Kumar has also been dealt with in this judgment. My lords, 3 cases from Kerala which finds oft being quoted in various judgments, be it of Maharashtra, be it of Delhi, has been dealt with. And then the concept of cases which are ex facie criminal, for which the judgments have gone steps ahead to say 17A approval would not be required, on the doctrine which your lordships pointed out on the last occasion, that such ex facie crimes or offences cannot be alleged to be in discharge or purported discharge of official duty. Now, therefore, to illustrate in which fact circumstances, my lords, I was told when I was young, my lords, that law is not laid down in vacuum. It is in context of a factual premise. That factual premise may occur on account of facts or on account of ingredients input contained in a statute. Therefore, my lords, kindly have a look at this judgment. My lords, with regard to fact, my lords, para 1 to 4 are important. My lords, the relief prayed for, my lords, I will take your lordships through to it, was quashing of an FIR instituted under Section 7 PC Act. My lords, para 2 your lordships will find that this Rajesh Kumar was a station house officer in charge of a police station, and he was conducting as an IU an investigation under a NDPS Act case. Then, my lords, para 3 and 4, my lords, I will read that out. I am just indicating that just in case my understanding has been poor and I am going to influence your lordships by wrong narration of fact, but I am only respondent number 2 files a complaint. Which complaint has been elaborately considered and set out in para 5. Now, my lords, let's see this judgment. The criminal miscellaneous petition under section 482 has been preferred on behalf of the petitioner seeking quashing of FIR.
Mr. Singh, you come to paragraph 5 on receiving of the complaint.
My lords, kindly see para 3 also, my lords, and 5 both. Para 2 contains the narration. He is an SHO in a case under NDPS Act, and respondent number 2's complaint is dealt with in para 3 and 4.
Yes.
The respondent number 2 has filed a complaint on 14/10/2020 before the additional SP Anti-Corruption Bureau, Jodhpur, alleging therein that he is resident of Kanpur and running a partnership pharma shop there along with his nephew Pawan Kumar Arora. It is stated in the complaint that on 18/9/2020, two persons approached complainant's nephew in the shop and introduced themselves as police personnel posted at police station Jawahar Nagar district so and so. One of them has introduced himself as Naresh Meena, constable, where another one has introduced himself as Sohan Lal, ASI. Both of them asked complainant's nephew that they want to procure some information regarding drugs, and thereafter they took his nephew to a hotel with so and so. They asked Pawan Kumar Arora to telephone the complaint to procure some information regarding the drugs. It was further alleged that those two persons had threatened the complainant that if he will not come to the hotel, they will take his nephew Pawan Kumar Arora along with them to Sri Ganganagar. It is also stated that the complainant immediately reached at the hotel where Naresh Meena Constable and Sohan Lal ASI asked him to give information regarding drugs which he has already supplied. Thereafter, Naresh Meena Constable reached to his shop along with his nephew while leaving the complainant and Sohan Lal ASI in the hotel. Thereafter, complainant's nephew informed him on telephone that he has supplied the information regarding medicine to Naresh Meena Constable, but he is not satisfied with the same and is taking him to a hotel Galaxy Plaza, Mal Road, Kanpur. Then Sohan Lal ASI took the complainant to the said house. There he asked Naresh Meena Constable about the notice. However, he refused to show the notice and told that since we are not satisfied with the information supplied by him, we'll take your nephew to Sri Ganganagar for interrogation. The complainant has further alleged that he begged of them, then Naresh Meena Constables bring out 2 copies of the notice signed by C. Rajesh Kumar, the petitioner. It is further alleged that both Naresh Kumar Meena Constable and Sohan Lal harassed the complainant and his nephew in the hotel up to late night, and ultimately Naresh Meena Constable said that the complainant that if he will give rupees 15 lakhs to them, they will leave his nephew.
We have followed that.
Because 15 lakh was given.
This court is not cutting you short, but the substance of the allegation is that he instigated another constable to pressurize the complainant to pay bribe for exonerating.
Yes.
So that is the substance.
Yes, bribe was demanded, accepted as per the complaint or set out in the complaint, and a further demand was made.
Yes. Now come to para 18. We have read that. As you were reading, I also read it.
I know, my lord, speed, at times with age catching up on you, and eyesight being not as strong as my lord's, then it takes a little time.
This is only to complete your promise, to fulfill your promise that you shall not go beyond Monday. So therefore, I am making you speed up.
I have come, para 19 onwards, the quotation of the Kerala judgment starts.
Yes.
I have taken. What I am trying to emphasize from the complaint
on the set of facts, this was different, which made out a case which cannot come under the cover of 17A. Is that right?
A, and therefore it was ex facie criminal having nothing to do with discharge of official duty. That's the point I wanted to make.
Yes.
Now kindly let us see in this process, by seeing this judgment, cumulatively, 3 judgments of the Kerala High Court and Devendra Kumar as well. Of course, Devendra Kumar I will deal. Devendra Kumar case, if I am not mistaken, is also a case of involving or regarding Mr. Asthana, the then